Thank you, Mr. Chairman. And I also, it's already been mentioned, but I want to thank the witnesses for being here today as well. This is obviously not an easy thing that it is to testify in public like this, and we certainly appreciate your bravery in doing this. And I think the behavior that's been discussed here is obviously outrageous and disgusting, and most of the individuals who you've been talking about on the other side ought to probably not only be sued or gone through arbitration, as the case may be, civilly, but ought to be behind bars. So I think the behavior that's been discussed here is criminal. And I know that as time passes and we as a society become more and more educated about this and how often it occurs, you know, we take it more and more seriously as we ought to. So again, thank you for being willing to be here today and to tell us about this. And as I say, most of these guys you're talking about ought to be in jail. Now, that being said, obviously we've had federal arbitration, and there's arbitration at the state level. It's been around for a long, long time. And it's one way to handle these types of things, not the only way. And there obviously ought to be more thought given up front, I think, on both sides about these contracts. And it's disturbing that such little time is given for an individual like yourself who's signing on at that employment early on as to what rights they may or may not be giving up. So I think that's something else we need to take a strong look at, is let's find out what people are actually signing. You know, they tell you, you know, never sign anything unless you read the fine print, you know, whether you're purchasing a car, whatever the case may be. And let's face it, we're all busy. They put the stuff in front of us and we sign it.
Would the gentleman yield?
I'd be happy to yield.
Yeah, but isn't the whole point that these women and others similarly situated are given contracts to sign? Here's your employment contract, and you may not X out the arbitration clause or the NDA, take it or leave it, and that's what we're dealing with.
Yeah, reclaiming my time, I agree with that, and I'm saying that's something that we do need to educate the public, and we all ought to be involved. You know, yes, we've got Democrats and Republicans here, but this is an issue I think we ought to be united on and ought to be out there protecting women or men in some cases that are harassed either at the workplace or anyplace else. You know, this is my 25th year in Congress, and on this Judiciary Committee, we handle an awful lot of very important issues, and most of us on both sides have supported programs and policies to protect individuals and assist victims of sexual exploitation, either in the workplace or in other places. So I think this is a timely, you know, discussion of this. But I've talked much longer than I wanted to. I want to get in a couple of questions. So obviously, the two rivaling principles here are, you know, getting justice certainly for a horrific thing that this individual has undergone, but doing it in a manner which, with all the lawsuits that are filed in this country, doing it in a timely way and doing it in a manner where you're going to get justice. And so I'd like to ask Ms. St. John and Ms. Perry, you had mentioned, Partial Perry, you had mentioned before about the time that is that you can get your case before the adjudicatory person, which in this case would be an arbitration panel. Oftentimes you have each side picks one, and those two arbitrators pick another arbitrator. So could you discuss that? You did somewhat in your testimony about the benefits of going that route. And is there anything that you would suggest in perhaps the discussion that I mentioned about having people more educated up front when they sign these employment agreements, that they're actually giving up their rights? And I'd let either one of you take that.
No, I think that's exactly right. Not every employer has these mandatory arbitration provisions. And I think if going in, employees know that there are employers that have them, there are employers who don't, maybe some are willing to remove them or talk through them, that would be helpful. And, you know, arbitration does tend to be faster, cheaper, easier way of resolving disputes, and that may be a way that is more beneficial to victims of sexual harassment and assault or any other workplace violation.
Thank you for that question, Congressman. I would echo what Ms. St. John said as well. I think also we need to refocus our analysis toward confidentiality and NDAs. And when those accompany arbitration provisions, that is a particularly pernicious setup. And in fact, 5 states have enacted legislation that indicates in certain claims under employment discrimination law, you may not use an NDA or a confidentiality provision, and so you are automatically given the opportunity to go immediately public, even though you are still in the arbitration process. I do think there's much to be said for investigating how we can look at the confidentiality provisions when they accompany arbitration itself.
Thank you. My time's expired.